Chapter 8 of the Negotiable Instrument Act of 1881, accepted in 1882 by all nations. We're going to go into dishonor, all right? They're not allowed to dishonor your instruments, and you're the enforcement. You're the one that holds them accountable if they do dishonor your instruments, all right? Especially here in America after 1933, Proclamation 2039, the 73rd Congress had established the fact that the new money under the new law was notes, drafts, bills of exchange, bankers' acceptance, and trade acceptances. Ladies and gentlemen, your instruments cannot be dishonored. Okay. Chapter 8 of Notice of Dishonor. Dishonor by non-acceptance. 91. A bill of exchange is said to be dishonored by non-acceptance when the drawee or on one of the several drawees not being partner makes default in acceptance upon being duly required to accept the bill, or where presentment is excused and the bill is not accepted. Where the drawee is incompetent to contract or the acceptance is qualified, the bill may be treated as dishonored. Dishonor by non-payment. A promissory note, bill of exchange, or check is said to be dishonored by non-payment when the maker of the note, acceptor of the bill, or drawee of the check makes default in payment upon being duly required to pay the same. By and to whom notice should be given. When a promissory note, bill of exchange, or check is dishonored by non-acceptance or non-payment, the holder thereof or some party thereto who remains liable thereon must be given notice that the instrument has been so dishonored to all other parties whom the holder seeks to make severally liable thereon, and to someone of several parties whom seek to make jointly liable thereon. When a bill of exchange is dishonored by non-acceptance, the drawer or an endorser to whom such notice is not given is discharged, but the rights of a holder in due course subsequent to the omission to give notice shall not be prejudiced by that omission. When a bill of exchange is dishonored by non-acceptance and due notice of dishonor is given, it shall be necessary to give notice of subsequent dishonor by non-payment unless the bill shall, in the meantime, have been accepted. Nothing in this section renders it necessary to give notice to the maker of the dishonored promissory note or the drawee or acceptor of the dishonored bill of exchange or check. Mode in which. 94. Notice of dishonor may be given to a duly authorized agent of the person to whom it is required to be given, or where he has died, to his legal representative, or where he has been declared an insolvent, to his assignee. May be oral or written, may, if written, be sent by post, and may be in any form, but it must inform the party to whom it is given, either in express terms or by reasonable intendment, that the instrument has been dishonored and in what way, and that he will be held liable thereon, and it must be given within a reasonable time after dishonor at the place of business, or in case such party has no place of business, at the residence of the party for whom it is intended. If the notice is duly directed and sent by post and miscarries, such miscarriage does not render the notice invalid. Party receiving must transmit notice of dishonor. 95. Any party receiving notice of dishonor must, in order to render any prior party liable to himself, give notice of dishonor to such party within a reasonable time, unless such party otherwise receives due notice as provided by Section 93. Agent for presentment. 96. When the instrument is deposited with an agent for presentment, the agent entitled to the same time to give notice to the principal as if he were the holder giving notice of dishonor, and the principal is entitled to a further like period give notice of dishonor when party to whom notice given is dead. 97. When the party to whom notice of dishonor is dispatched is dead, but the party dispatching the notice is ignorant of his death, the notice is sufficient. When notice of dishonor is unnecessary. 98. Notice of dishonor is unnecessary, A, when it is dispensed with by the party entitled thereto. B, in order to charge the drawer when he has countermanded payment. C, when the party charged could not suffer damage for want of notice. D, when the party entitled to notice cannot after due search be found, or the party bound to give notice is, for any other reason, unable without any fault of his own to give it. E, to charge the drawers when the acceptor is also a drawer. F, in the case of a promissory note which is not negotiable. G, when the party entitled to notice, knowing the facts, promises unconditionally to pay the amount due on the instrument. Chapter 9 of Noting and Protest. Noting. 99. When a promissory note or a bill of exchange has been dishonored by non-acceptance or non-payment, the holder may cause such dishonor to be noted by a notary public upon the instrument or upon a paper attached thereto, or partially upon each. Such note must be made within a reasonable time after dishonor, and must specify the date of dishonor, the reason, if any, assigned for such dishonor, or, if the instrument has not been expressly dishonored, the reason why the holder treats it as dishonored, and the notary's charges. Protest. 100. When a promissory note or a bill of exchange has been dishonored by a non-acceptance or non-payment, the holder may, within a reasonable time, cause such dishonor to be noted and certified by a notary public. Such certificate is called a protest. Protest for better security. When the acceptor of a bill of exchange has become insolvent, or his credit has been publicly impeached before the maturity of the bill, the holder may, within a reasonable time, cause a notary public to demand better security of the acceptor, and on its being refused, may, within a reasonable time, cause such facts to be noted and certified as aforesaid. Such certificate is called a protest for better security. Contents of protest. 101. A protest under Section 100 must contain A, either an instrument itself or a literal transcript of the instrument and of everything written or printed thereupon. B, the name of the person for whom and against whom the instrument has been protested. C, a statement that payment or acceptance or better security, as the case may be, has been demanded of such person by the notary public, the terms of his answer, if any, were a statement that he gave no answer or that he could not be found. D, when the note or bill has been dishonored, the place and time of dishonor, and when better security has been refused, the place and time of refusal. E, the subscription of the notary public making the protest. F, if the event of an acceptance for honor or of a payment for honor, the name of the person by whom, of the person for whom, and the manner in which such acceptance or payment was offered and effected. A notary public may make the demand mentioned in clauses C of this section, either in person or by his clerk, or where authorized by agreement or usage by registered letter. Notice of protest. 102. When a promissory note or a bill of exchange is required by law to be protested, notice of such protest must be given instead of notice of dishonor, in same manner and subject to the same condition, but the notice may be given by the notary public who makes the protest. Protest for non-payment after dishonor by non-acceptance. 103. All bills of exchange drawn payable at some other place than the place mentioned as the residence of the drawee, and which are dishonored by non-acceptance, may without further presentment to the drawee be protested for non-payment in the place specified for payment, unless paid before or at maturity. Protest of foreign bills. 104. Foreign bills of exchange must be protested for dishonor when such protest is required by the law of the place where they are drawn, when noting equivalent to protest. 104A. For the purposes of this act, where a bill or a note is required to be protested within a specified time or before some further proceeding is taken, it is sufficient that the bill has been noted for protest before the expiration of the specified time or the taking of the proceedings, and the formal protest may extend at any time thereafter as of the date of the noting. Chapter 10 of Reasonable Time. Reasonable Time. 105. In determining what is reasonable time for presentment, for acceptance, or payment for giving notice of dishonor and for noting regard shall be had to the nature of the instrument and the usual course of dealing with respect to similar instruments, and in calculating such time, public holidays shall be excluded. Reasonable time of giving notice of dishonor, 106. If the holder and the party to whom notice of dishonor is given carry on business or live, as the case may be, in different places, such notice is given within a reasonable time if it is dispatched by the next post or on the day next after the day of dishonor. If the said parties carry on business or live in the same place, such notice is given within a reasonable time if it is dispatched in time to reach its destination on the day next after the day of dishonor. Reasonable time for transmitting. 107. A party receiving notice of dishonor who seeks to enforce his right against a prior party transmits the notice within a reasonable time if he transmits it within the same time after its receipt as he would have had to give notice if he had been the holder. Chapter 11 of acceptance and payment for honor and reference in case of need. Acceptance for honor, 108. When a bill of exchange has been noted or protested for non-acceptance or for better security, any person not being a party already liable thereon may, with the consent of the holder, by writing on the bill, accept the same for the honor of any party thereto. How acceptance for honor must be made. 109. A person desiring to accept for honor must, by writing on the bill under his hand, declare that he accepts under protest the protested bill for honor of the drawer or of a particular endorser whom he names, or generally for honor. Acceptance not specifying for whose honor it is made. 110. Where the acceptance does not express for whose honor it is made, it shall be deemed to be made for the honor of the drawer. Liability of acceptor for honor, 111. An acceptor for honor binds himself to all parties subsequent to the party for whose honor he accepts to pay the amount of the bill, if the drawee do not. And such party and all prior parties are liable in their respective capacities to compensate the acceptor for honor for all losses or damages sustained by him in consequence of such acceptance. But an acceptor for honor is not liable to the holder of the bill unless it is presented, or in case the address given by such acceptor on the bill is a place other than the place where the bill is made payable, forwarded for presentment, not later than the day next, the day of its maturity. When acceptor for honor may be charged. 112. An acceptor for honor cannot be charged unless the bill has at its maturity been presented to the drawee for payment and has been dishonored by him and noted or protested for such dishonor. Payment for honor, 113. When a bill of exchange has been noted or protested for non-payment, any person may pay the same for the honor of any party liable to pay the same, provided that the person so paying or his agent in that behalf has previously declared before a notary public that the party for whose honor he pays, and that such declaration has been recorded by such notary public. Right of payer for honor, 114. Any person so paying is entitled to all the rights in respect of the bill of the holder at the time of such payment, and may recover from the party for whose honor he pays all sums so paid, with interest thereon, and with all expenses properly incurred in making such payment. Drawee in case of need. 115. Where a drawee in case of need is named in a bill of exchange or in any endorsement thereon, the bill is not dishonored until it has been dishonored by such drawee. Acceptance and payment without protest. 116. A drawee in case of need may accept and pay the bill of exchange without previous protest. Chapter 12 of compensation. Rules as to compensation. 117. The compensation payable in cases of dishonor of a promissory note, bill of exchange, or check by any party liable to the holder or any endorser endorsee shall be determined by the following rules. A holder entitled to the amount due upon the instrument together with the expenses properly incurred in presenting, noting, and protesting it. B, when the person charged resides at a place different from that at which the instrument was payable, the holder is entitled to receive such sum at the current rate of exchange between the two places. C, an endorser who, being liable, has paid the amount due on the same is entitled to the amount so paid with interest at 6% per annum from the date of the payment until tender or realization thereof, together with all expenses caused by the dishonor and payment. D, when the person charged and such endorser resides at different places, the endorser is entitled to receive such sum at the current rate of exchange between the two places. E, the party entitled to compensation may draw a bill upon the party liable to compensate him, payable at sight or on demand, for the amount due to him, together with all expenses properly incurred by him. Such bill must be accompanied by the instrument dishonored and the protest thereof, if any. If such bill is dishonored, the party dishonoring the same is liable to make compensation thereof in the same manner as in the case of the original bill. Chapter 13. Special rules of evidence. Presumption as to negotiable instruments, of consideration, B, as to date, C, as to time of acceptance, D, as to time of transfer, E, as to order of endorsement, F, as to stamp, and G, that holder is a H. Okay, special rules of evidence, 118. Until the contrary is proved, the following presumptions shall be made. These are presumptions that are tied to the promissory note, bill of exchange, and checks. Until the contrary is proved, the following presumptions shall be made. A, that every negotiable instrument was made or drawn for consideration, and that every such instrument, when it has been accepted, endorsed, negotiated, or transferred, was accepted, endorsed, negotiated, or transferred for consideration. B, that every negotiable instrument bearing a date was made or drawn on such date. C, that every accepted bill of exchange was accepted within a reasonable time after its date and before its maturity. D, that every transfer of a negotiable instrument was made before its maturity. E, that the endorsement appearing upon a negotiable instrument were made in the order in which they appear thereon. F, that a lost promissory note, bill of exchange, or check was duly stamped. G, that the holder of a negotiable instrument is a holder in due course, provided that where the instrument has been obtained from its lawful owner or from any person in lawful custody thereof by means of an offense or fraud, or has been obtained from the maker or acceptor thereof by means of an offense or fraud, or for unlawful consideration, the burden of proving that the holder is a holder in due course lies upon him. Presumption on proof of protest, 119. In a suit upon an instrument which has been dishonored, the court shall, on proof of protest, presume the fact of dishonor unless and until such fact is disproved. Estoppel against denying original validity of instrument. 120. No maker of a promissory note and no drawer of a bill of exchange or check and no acceptor of a bill of exchange for the honor of the drawer shall, in a suit thereon, by a holder in due course, be permitted to deny the validity of an instrument as originally made or drawn. Estoppel against denying capacity of payee to endorser, to endorse. No maker of a promissory note and no acceptor of a bill of exchange payable to order shall, in a suit thereon, by a holder in due course, be permitted to deny the payee's capacity at the date of the note or bill to endorse the same. Estoppel against denying signature or capacity of prior party. 122. No endorser of a negotiable instrument shall, in a suit thereon, by a subsequent holder, be permitted to deny the signature or capacity to contract or any prior party to the instrument. Chapter 14. Special provisions relating to checks. Revocation of banker's authority. 122A. The duty and authority of a banker to pay a check drawn on him by his customer are determined by 1. Countermand of payment. 2. Notice of the customer's death. 3. Notice of adjudication of the customer as an insolvent. Check cross generally. Where a check bears across its face an addition of the words and company or any abbreviation thereof between two parallel transverse lines, or of two parallel transverse lines simply, either with or without the words not negotiable, that addition shall be deemed a crossing, and the check shall be deemed to be crossed generally. Check crossed account payee. 123. Where a check crossed generally bears a cross, its face, an addition of the words account payee between the two parallel transverse lines constituting the general crossing, the check, besides being crossed generally, is said to be crossed account payee. Check crossed account payee. 2. When a check is crossed account payee, A, it shall cease to be negotiable, and B, it shall be the duty of the banker collecting the payment of the check to credit the proceeds thereof only to the account of the payee named in the check. Check cross specially. Where a check bears a cross, its face, an addition of the name of a banker, either with or without the words not negotiable, that addition shall be deemed a crossing, and the check shall be deemed to be crossed specially and to be crossed to that banker. Crossing after issue. Check crossed specially. 125. Where a check is uncrossed, the holder may cross it generally or specially, crossing after issue. Where a check is crossed generally, the holder may cross it specially. Where a check is crossed generally or specially, the holder may add the words not negotiable. Where a check is crossed specially, the banker to whom it is crossed may again cross it specially to another banker, his agent, for collection. When an uncrossed check or a check crossed generally is sent to a banker for collection, he may cross it specially to himself. 125A. Crossing a material part of a check. A crossing authorized by this act is a material part of the check. It shall not be lawful for any person to obliterate or except as authorized by this act to add or to alter the crossing. Payment of check crossed generally. 126. Where a check is crossed generally, the banker on whom it is drawn shall not pay it otherwise than to a banker. Payment of check crossed specially. Where a check is crossed specially, the banker on whom it is drawn shall not pay it otherwise than to a banker to whom it is crossed or his agent for collection. Payment of check crossed specially more than once. Where a check is crossed specially to more than one banker, except when crossed to an agent for the purpose of collection, the banker on whom it is drawn shall refuse payment thereof. Payment in due course of crossed check. Where the banker on whom a crossed check is drawn in good faith and without negligence pays it, if crossed generally to a banker, and if crossed specially to the banker to whom it is crossed, or his agent for collection being a banker, the banker paying the check, and in case of such check has come to the hands of the payee, the drawer thereof shall respectively be entitled to the same rights and be placed in the same position in all respects as they would respectively be entitled to and placed in if the amount of the check had been paid to and received by the true owner thereof. Payment of crossed check out of due course. Any banker paying a check crossed generally otherwise than to a banker, or a check crossed specially otherwise than to the banker to whom the same is crossed, or his agent for collection being a banker, shall be liable to the true owner of the check for any loss he may sustain owing to the check having been so paid, provided that where a check is presented for payment which does not at the time of presentment appear to be crossed, or to have had a crossing which has been obliterated, added to, or altered otherwise than as authorized by this act, the banker paying the check in good faith and without negligence shall not be responsible or incur any liability, nor shall the payment be questioned by reason of the check having been crossed, or of the crossing having been obliterated, or having been added to or altered otherwise than as authorized by this act, and of payment having been made otherwise than to a banker, or to the banker to whom the check is or was crossed, or to his agent for collection, being a banker, as the case may be. Check bearing not negotiable. 130. A person taking a check crossed generally or specially bearing in either case the words not negotiable shall not have and shall not be capable of giving a better title to the check than that which the person from whom he took it had. Non-liability of banker receiving payment of check. Check bearing non-negotiable. 131. Subject to the provisions of this act relating to the checks crossed account payee, where a banker in good faith and without negligence receives payment for a customer of a check crossed generally or specially to him, and the customer has no title or a defective title thereto, the banker shall not incur any liability to any true owner of the check by reason only of having received such payment. Non-liability of the banker receiving payment of the check. Explanation. A banker receives payment of a crossed check for a customer within the meaning of this section, notwithstanding that credits his customer's accounts with the amount of the check before receiving payment thereof. Application of chapter to draft. 131. The provisions of this chapter shall apply to any draft as defined in sections 85A, as if the draft were a check. Protections to banker crediting check crossed account payee. Where a check is delivered for collection to the banker which does not at the time of such delivery appear to be crossed account payee, or to have had a crossing account payee which has been obliterated or altered, the banker in good faith and without negligence collecting payment of the check and crediting the proceeds thereof to the customer shall not incur any liability by reason of the check having been crossed account payee, or of such crossing having been obliterated or altered, and of the proceeds of the check having been credited to a person who is not the payee thereof. Check not operating as assignment of funds. 131C. A check of itself does not operate as an assignment of any part of the funds to the credit of the drawer with the banker. Chapter 14. Special provisions relating to bills of exchange. Several drawees. 131. A bill of exchange may be addressed to two or more drawees, whether they are partners or not, but an order addressed to two drawees in the alternative, or to two or more drawees in succession, is not a bill of exchange, in whose favor a bill may be drawn. 131E. A bill of exchange may be drawn payable to or to the order of the drawer, or it may be drawn payable to or to the order of the drawee. When presentment for acceptance is necessary. 131F. A bill of exchange, in order to fix the acceptor with liability, must be presented for acceptance before it is presented for payment. When presentment is excused. 131G. Presentment for acceptance is excused, and a bill of exchange may be treated as dishonored by non-acceptance. A. Where the drawee is dead, or is insolvent, or is a fictitious person, or a person not having capacity to contract by bill of exchange. B. Where at the due date for presentment, the drawee cannot, after reasonable search, be found at the place at which the bill is to be presented. C. Where after the exercise of reasonable diligence, such presentment cannot be effected. D. Where, although the presentment has been irregular, acceptance has been refused on some other grounds. Holders' rights of recourse against drawn and endorsers. 131H. Subject to the provisions of this act, when a bill of exchange is dishonored by non-acceptance, an immediate right of recourse against the drawer and endorsers occurs to the holder, and no presentment for payment is necessary. Holder may refuse qualified acceptance. 131I. The holder of the bill of exchange may refuse to take a qualified acceptance, and if he does not obtain an unqualified acceptance, may treat the bill as dishonored by non-acceptance. Set of bills. 132. Bills of exchange may be drawn in part, each part being numbered, and contained a provision that it shall continue payable only so long as the other remain unpaid. All the parts together make a set, but the whole set constitutes only one bill and is extinguished when one of the parts, if a separate bill, would be extinguished. Exception: when a person accepts or endorses different parts of the bill in favor of different persons, he and the subsequent endorsers of each part are liable on such part as if it were a separate bill. Holder of first acquired part entitled to all. 133. As between holders in due course, or different parts of the same set, he who first acquired title to his part is entitled to the other part and the money represented by the bill. Chapter 15 of International Law. Law governing liability of parties to a foreign instrument. In the absence of the contract to the contrary and subject to the provisions of sections 136 in the case of a foreign promissory note, bill of exchange, or check, a. The law of the place where the instrument was made or drawn or accepted or negotiated shall determine the capacity of the parties and the validity of the instrument, or, as the case may be, of its acceptance or negotiation, provided that such instrument shall not be invalid or inadmissible in evidence by reason only that it was not stamped or not sufficiently stamped according to the law of the place where it was made or drawn. The law of the place where such instrument is payable shall determine the liability of the parties thereto, the duties of the holder with respect to the presentment for the acceptance of the or payment, the date of the maturity of the instrument, what constitutes dishonor, the necessity for and sufficiency of a protest or notice of dishonor, all questions relating to payment and satisfaction, including the currency in which and the rate of exchange at which the instrument is to be paid. Illustrations. A bill of exchange was drawn by A in California, where the rate of exchange is 25%, and accepted by B, payable in Washington, where the rate of exchange is 6%. The bill is endorsed in Bangladesh and is dishonored. An action on the bill is brought against B in Bangladesh. He is liable to pay interest at the rate of 6% only, but if A is charged as drawer, A is liable to pay interest at the rate of 25%. Omitted. 135, omitted by Section 53 of the Negotiable Instrument Amended Ordinance 1962, Ordinance number XLIX of 1962. Instruments made, etc., outside Bangladesh, but in accordance with their laws. 136. If a negotiable instrument is made, drawn, accepted, or endorsed outside Bangladesh, but in accordance with the law of Bangladesh, the circumstances that any agreement evidenced by such instrument is invalid according to the law of the country wherein it was entered into does not invalidate any subsequent acceptance or endorsement made thereon within Bangladesh. Presumptions as to foreign law. 137. The law of any foreign country regarding promissory notes, bills of exchange, and checks shall be presumed to be the same as that of Bangladesh unless and until the contrary is provided. 21. Chapter XVI on penalties in case of dishonor, certain checks for insufficiency of funds in the accounts, dishonor of checks for insufficiencies, etc. 138. Where any check drawn by a person on an account maintained by him with a banker for payment of any amount of money to another person from out of that account of funds in the account is returned by the bank unpaid, either because of the amount of money standing to the credit of that account is insufficient to honor the check, or that it exceeds the amount arranged to be paid from the account by the agreement made with that bank, such person shall be deemed to have committed an offense and shall, without prejudice to any other provisions of this act, be punished with imprisonment for the term, which may extend to 1 year, or with fine, which may extend to 24 thrice the amount of the check, or with both. 3. Notwithstanding anything contained in subsection 1 and 2, the holder of the check shall retain his rights to establish his claim through civil court if whole or any part of the value of the check remains unrealized, provided that nothing contained in this section shall apply unless the check has been presented to the bank within a period of 6 months from the date on which it is drawn, or within the period of its validity, whichever is earlier. The payee or the holder in due course of the check, as the case may be, makes a demand for the payment of the said amount of money by giving a notice in writing to the drawer of the check within 30 days of the receipt of information by him from the bank regarding the return of the checks as unpaid, and C, the drawer of such check fails to make the payment of the said amount of the money to the payee, or, as the case may be, to the holder in due course of the check within 26 to 30 days of receipt of said notice. 27 is blank. 28, the notice required to be served under Clause B of subsection 1 shall be served in the following manner: A, by delivering it to the person on whom it is to be served, or B, by sending it by registered post with acknowledgement due to that person at his usual or last known place of abode or business in Bangladesh, or C, by publication in a daily Bangla national newspaper having wide circulation. Where any fine is realized under subsection 1, any amount up to the face value of the check, as far as is covered by the fine realized, shall be paid to the holder, notwithstanding anything contained in subsection 1, and 2, the holder of the check shall retain his right to establish his claim through civil court if whole or any part of the value of the check remains unrealized. Restrictions in respect of appeal. Notwithstanding anything contained in the Code of Criminal Procedures of 1898, no appeal against any order of sentence under subsection 1 of section 138 shall lie, unless an amount of not less than 50% of the amount of the dishonored check is deposited before filing the appeal in the court which awarded the sentence. Omitted is 139. Offense of 140. If the person committing an offense under section 138 is company, every person who, at the time of the offense was committed, was in charge of and was responsible to the company for the conduct of the business of the company, as well as the company, shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly, provided that nothing contained in this subsection shall render any person liable to punishment if he proves that the offense was committed without his knowledge, or that he had exercised all due diligence to prevent the commission of such offense. 2, notwithstanding anything contained in subsection 1, where any offense under this act has been committed by a company and it is proved that the offense has been committed with the consent of or conveyance of or is attributable to any negligence of any part of any director, manager, secretary, or other officer of the company, such director, manager, secretary, or other officer shall also be deemed to be guilty of that offense and shall be liable to be proceeded against and punished accordingly. Explanation for the purpose of the section. A company means any body corporate and includes a firm or other association of individuals. And B, director in relation to a firm means a partner in the firm. 141, cognizance of offense, notwithstanding anything contained in the Code of Criminal Procedure of 1898, Act 5 of 1898. No court shall take cognizance of any offense punishable under sections 138 except upon a complaint in writing made by the payee, or, as the case may be, the holder in due course of the check. B, such complaint is made within 1 month of the date on which the cause of action arises under clause C of the proviso to sections 138. 31, no court inferior to the court of to that of a court of session shall try any offense punishable under sections 138. Throughout this act, except otherwise provided, the words Bangladesh government and the Taka were substituted for the words Pakistan, central government, and RS, or rupees, respectively, by section 3 and 2, schedule of the Bangladesh laws, revisions, and Declaration Act of 1973, Act number 8. Of 1973. So as you can see, this is the Bangladesh one for negotiable instruments, but you can find it in every state. You have one that has a Negotiable Instruments Act. All right, ladies and gentlemen. So I want you guys to go check that out. It's very important, and you're going to find out that every state is going to reference the UCC, ladies and gentlemen. So when you're dealing with negotiable instruments, you want to become familiar with the Uniform Commercial Code. All right. Thanks for joining me. I really appreciate you guys, and we'll talk to you soon.